Hello everyone, this is Adrian with PrepAgent, and today we're going to talk contracts. Hope everybody's having a great day. Go ahead and let me know via thumbs up in the chat or something if you can hear me. Just let me know that you can hear me. And make sure to wish Mary good luck on her exam. She's testing in the morning. So good luck to everybody taking your exams this week. We're going to do our best to get you prepared. Cynthia says, hello, Mr. Joe and Mr. Adrian. Hello, Mrs. Cynthia. Looks like everybody can hear. So we'll go ahead and get started with today's webinar, contracts. Before we get into questions on the board, I was asked to cover ostensible authority, I believe, and something else. So ostensible authority is a situation where any reasonable person could assume there to be an agency or a contract in place, right? So if you have, you may have heard the term ostensible agency. It's the same thing. It's also very similar to implied agency, excuse me. But ostensible authority is just a situation where two parties' actions and the situation make it so that any reasonable person would think, oh yeah, of course they have an agreement here. These two are acting like they have an agreement. You know, I think Joe always says, if it walks like a duck, talks like a duck, quacks like a duck, it's a duck. That is ostensible authority, ostensible agency, which are also the same, very similar things anyway, to implied agency. So hopefully that makes sense on that. And then options as well. We will cover some questions that have to do with options today, but all an option is exactly what it sounds like, I guess. You know, like it's an option to do something in the future. You're going to pay for that option. You're going to exchange some consideration to open up that option. So the sort of standard example that we come across a lot is a lease with an option to buy. So let's say you lease a condo for 6 months, and you tell the person like, hey, you know, like I know you're thinking about selling this. We talked about it. I might be interested. Can I give you $1,000 to make sure that, you know, like I have the option to buy this if you do choose to sell when my lease is up? And the seller says, okay, sounds like good, sounds like a deal. And they have an option agreement. So hopefully that explains options to everybody as well. We're also going to come up on some questions, like I said, with options. I do see somebody confusing options with a tenancy for years. That's not quite the case. A tenancy for years is still just a lease. The option is a clause in the contract that would give the lessee the option to buy at the end of it. You know, options are not restricted to lessees and whatever. They can come up in all sorts of situations. But let's not confuse that with the actual lease itself. The option is to do something else, usually beyond the lease, usually to purchase. Hopefully that makes sense to everybody. And without further ado, we're going to jump into questions on the board. Whatever an ado is, we're not going to have any more of them. First up, Henry made an offer to purchase real property. However, he died of a heart attack before the listing broker could notify him of the signed acceptance by the seller. Based on these facts, which of the following is true? What does everybody think on this one? Malou, plottage, and assemblage, will actually come under property transfer. They're not really topical to today, so you can use the real estate dictionary to look those up. But basically, those are just ways of combining lots of property. Diana asks, could you also say options or choices? You could. It's sort of a one-way choice, though, as we'll get into a little bit later. The optionor is bound to the option contract. It's still a contract, and the optionor is bound to it, which is why it's a unilateral contract, as Joe was saying earlier. The optionee has the choice, but the optionor does not. But that's why they use the word option, right? Because the optionee has the option of executing the contract or not. If the optionor agrees to give the option, they're going to get paid something. They're going to get some consideration in exchange for their leaving that option open to the optionee. So hopefully that makes sense to everybody there. That's why the optionor does not have the option. It's why they're bound to the contract, because they've probably already been paid something for that option. All right, back to the question on the board. Henry made an offer to purchase real property. However, he died of a heart attack before the listing broker could notify him of the signed acceptance by the seller. Based on these facts, which of the following is true? D. The death of Henry constituted a revocation of the offer. And the reason I wanted to throw this one in here is because this one does confuse people a lot in question feedback. And the way that I like to look at this is that because Henry did not confirm the acceptance of the contract was never completed, right? We talk about the three components to offer an acceptance, which is offer, acceptance, and then communication of the acceptance or confirmation of the acceptance. Henry didn't get the chance to do that because he passed away before that could happen. And it wouldn't really be fair to hold Henry to a contract that he didn't know he was making. It would obviously be his estate that would be bound to follow through on the contract. And so that's kind of how I remember this particular situation, is that, it's not fair to Henry. Oh, Henry. It's not fair to Henry to hold him to a contract that he didn't know he was making. Leslie asks, how about if confirmed the contract? So if if Henry had received the acceptance and said, okay, we're good, and then he croaked right after that, then the contract would technically still be valid. It would probably end up in a court to decide all of that. But then you would have a really strong argument that it would be valid if he had confirmed the acceptance of it. Revocation can only happen before the offer is accepted. Once the offer is accepted, you can't really revoke it anymore. And again, the reason that I hedge around those things and I say you can't really revoke it is because the ultimate decider, the ultimate judge of that is going to be a judge or a court when it's super gray like that. But in most cases, you can't revoke a contract once it's been accepted. And Alexa says, I thought because it went through his agent, it was then a contract. His agent is not going to be held to the terms of the contract, Alexis. Henry and Henry's estate would be held to the terms of the contract. So unless his agent had absolute power of attorney, which is what we call a universal agent, then that's not going to be the case. But if his agent was a universal agent and he had power of attorney and he confirmed the acceptance, then the contract would be good. And last one before we move on, R.A. Smoot says, offer was accepted. The offer was accepted by the seller, yes, but that acceptance never got communicated to Henry, which is why it's not a valid contract. All right. So a salesperson who prepares a written listing agreement with the seller is helping to create a contractual relationship between the A, salesperson's broker and the seller, B, salesperson and the listing broker, C, salesperson and the buyer, or D, salesperson and the seller. What does everybody think here? Dale says, I forgot the name of the protection clause. Not entirely, Dale. Protection period clause is one way we refer to it. I've also seen it referred to as a delay clause, but I wouldn't use that very much because that has other uses as well. But protection period is one. It's the only one I can think of right now. If anybody else remembers another one, then go ahead and throw that up. So a salesperson who prepares a written listing agreement with the seller is helping to create a contractual relationship between the salesperson's broker and the seller. So it looks like we mostly understand that the actual listing agreement is always going to be between the broker, technically, the responsible party, and the seller. Even if the salesperson is doing all the go-betweens and stuff like that, they're ultimately not held responsible in the same way that the broker is. Got one person saying that it's having audio problems. Does anybody else having audio problems? Throw it up in the chat if that's the case, and I'll see what I can do. Otherwise, we're just going to move right along. Everybody says no. If Anne can hear me, y'all should be able to hear me. Great. So, next on our question board, under a sales contract, the legal remedy that may be used to force the seller to consummate the sale is called A, writ of execution, B, foreclosure, C, specific performance, or D, unlawful detainer. Oh, Joe says I sound great, never better. I did my warm-up exercises before the webinar, so. Me. Nobody really does that anymore. That was kind of a thing in the 90s. Everybody did their me's and their you's. Okay, under sales contract, the legal remedy that may be used to force the seller to consummate the sale is called C, specific performance. Great job. It looks like everybody got that one right. Some people this week were confused on that one, and so that's why I wanted to bring that up. Throw that in here. Santana does his me's. That's fantastic. Christopher says vocalists do. Cynthia says that my vocal exercises are working, so all right. Leslie asks what a writ of execution is. Joe, could you maybe take a look with that? If not, I'm not sure off the top of my head right now, Leslie, when that is applicable. I know that it's legal. I know that it's court related. Awesome. Joe's going to take a look. And we are going to move to shopping centers. If the owners of a shopping center want a major department store's lease to provide rental payments that reflect the store's sales, they are most likely going to use which of the following types of leases? Is that A, a flat fee, B, a percentage, C, a gross, or D, net? What does everybody think? This confuses a lot of people. But if you end up in commercial real estate, it could actually be very relevant. So to go back to the previous question, Joe says a writ of execution is a court order granted to put in force a judgment of possession obtained by a plaintiff from a court. So that's probably, if I'm reading that right, going to relate to us mostly through foreclosures. Joe says basically a judicial order that a judgment be enforced, right? Okay, so if the owners of a shopping center want a major department store's lease to provide rental payments that reflect the store's sales, they are most likely to use which of the following types of leases? percentage, B. So the reason that I wanted to throw this in here is because a lot of times people get them confused with gross. Can anybody tell us what a gross lease is? What is the unique characteristic of a gross lease that separates it from both percentage and net leases? A gross lease is fixed amount, says Olafunky Nike Ola, exactly. And what about a net lease? Mark said gross is like a normal lease you would have in your apartment building. Exactly. And a net lease pays taxes, pays everything. Taxes, insurance, and utilities, right? Taxes, insurance, utilities, is that right? Or was maintenance part of it? Maintenance, utilities, insurance. Yep, okay. Often referred to as a triple net, but it's also the same thing as a net lease. Dale says taxes too, taxes too. So on top, the reason that they call it a triple net, Dale, is because on top of your rent, you're often paying the trifecta of tax, maintenance, and insurance with that type of lease. And so that's it. Hopefully that makes sense to everybody. We're going to see what's going on with Mr. Jones here. Jones' offer to buy Brown's house has been accepted, but the actual sale will not take place for 3 months. Until then, their written sales contract is considered to be A. Conditional, B. Voided, C. Voidable, or D. Executory. What does everybody think here? What is the status of the contract? And this is kind of one of those you want to read completely and carefully. I will say the first time I read it, I thought it was asking something else. All right, Jones' offer to buy Brown's house has been accepted, but the actual sale will not take place for 3 months. Until then, their written sales contract is considered to be D. Executory, as opposed to executed, as Jennifer Lawrence said. An executed contract would be one that has been completely performed and taken place. Nice job. Everybody's doing really great with the contract work. I specifically chose some questions that I thought might trip us up, give us some good points of discussion, but you guys are killing it today. And Adrian says, shoot, that's right. That's right, Adrian. Right. A buyer paid $2,800 for an option to purchase a property within 90 days for $450,000. Within a month, the buyer made an offer to buy the property immediately for $425,000. Which of the following is true in this situation? Is that A, the option money is forfeited, B, the buyer is in default of the option agreement, C, both parties are in violation of contract law, or D, the owner may accept the offer for $425,000. What does everybody think here? A buyer paid $2,800 for an option to purchase a property within 90 days for $450,000. Within a month, the buyer made an offer to buy the property immediately for $425,000. Which of the following is true? D, the owner may accept the offer for $425,000. Dale says, don't tell. Sorry, Dale. I couldn't help it. I wasn't reading the chat board. Before we came up, if there's any questions about this, go ahead and let me know. It seems like everybody was pretty on point with that. And the idea here mostly being that even though the owner has extended an option, the option to exercise is on the optionee's side, right? On the buyer's side. And so if the optionee, the buyer, comes and says, hey, actually, I'll do it here if you agree, the owner is completely within his rights to do that. Next on the board, the buyer has been held to be in default on a contract of sale. If buyer and seller had not agreed on liquidated damages, the seller could do which of the following? Is that A, obtain a court order preventing the buyer from purchasing another property, B, arrange for criminal proceedings against the buyer, C, require the buyer to find a substitute purchaser, D, sue the buyer for compensatory damages. What does everybody think here? This one I thought was, I had to read it a couple times personally too. Looks like we have a pretty good consensus here as well. But liquidated damages did come up, I think, towards the tail end of last week, either in the webinar or in discussion with somebody, but it was kind of a back and forth. So I thought it would be good to go over. Right, the buyer has been held to be in default on a contract of sale. If the buyer and seller had not agreed on liquidated damages, the seller could do which of the following? D, sue the buyer for compensatory damages. And that's what everybody else said. The easy one to confuse it with is B, arrange for criminal proceedings against the buyer. Can anybody tell me what the immediate clue is here? Why that would absolutely not be? And R.A. Smoot kind of clued into it with criminal. Anybody have an idea? Leslie asks, just to confirm, only the seller can sue for liquidated damages. Leslie, I don't think it's true that only the seller can sue for liquidated damages, but it's most common that they're going to do it because what they're looking to do with liquidated damages is make up the difference between what they sold their property for and what they were going to sell it to the buyer for. So it's the same thing as specific performance. Usually only a buyer is going to sue for specific performance because they want the seller to go through with the sale. You know, they're not the only one that can sue for specific performance. They're just the only person it makes any sense for. And so let's get back to my question here. And the question again was, why is this not a criminal situation? Or why do you know that this isn't a criminal situation? And Kirsten Wolf said it perfectly. It's a civil matter, not criminal. And so anytime that you see a situation like this and it's contract, it's dealing with a contract between a buyer and a seller, or just a contract, it's a contract dispute, right? That's what's going on here is a contract dispute. That's not criminal. And so if you see that as an answer, you can immediately wipe that out. If it's criminal, it's because the government is bringing action against you. When it's action between two civilians, not criminal, it's civil. Hopefully that makes sense. Yash asks, what is it called if the seller sues? That depends on what the seller would be suing for. Yash, the last question, well, here we're talking about the seller suing for liquidated damages. And the reason is because after the seller ends up selling the property, they can calculate losses of time and profit from the sale of the property and then seek to recover those from the defaulting buyer. All right, now we're starting to get into the tricky stuff a little bit. And then last question before we move on, Ashley asks, what are liquidated damages exactly? That's a clause in a contract, Ashley, that specifies if the contract is not carried out by such and such party, then these are the damages that will be due. And a lot of times, there can be liquidated damages both ways, but that's all it is. It's just an agreed to amount um, that one party has to pay in the case of a contract default. All right. Wow. Looks like everybody's got this. When zoning changes occur, but owners are allowed to continue with non-conforming uses, this is A, subordination clause, B, release clause, C, grandfather clause, or D, acceleration clause. What do you all think here? When zoning changes occur, but owners are allowed to continue with non-conforming uses, this is C, grandfather clause. Nice work. That one confuses people. They think that non-conforming and grandfather are two different things. It's more that non-conforming is a type of grandfather clause. RA asks if we can cover land use sometime. I'll look into that, RA. Land use is mostly state specific, and we don't do a lot of state specific webinars because we want the material to be applicable to everybody who's attending. Next on the board, if a principal no longer desires the broker to act for him during the period of an exclusive right to sell listing, he may A, be forced to sell his property, B, not revoke the agency because an exclusive right to sell listing is an irrevocable contract, C, revoke the agency created by the listing contract, or D, revoke the agency created by the listing contract, but may be liable for damages. Yash asks, what's a subordination clause? A subordination clause, Yash, is a clause in a contract, usually has to do with liens on a property, and it allows a lien or like a mortgage, like a second or third mortgage or a HELOC, a home equity line of credit, to be placed in an inferior position to a loan that is newer than it. So most of the time with liens, they are paid back in the order that they're recorded. So when you take out a second mortgage, but let's say you have a HELOC, a home equity line of credit on your property, well, when you take out that second mortgage, what it technically does most of the time is pays off your first mortgage. So what that means is you're left with two liens on the property, a HELOC and a second mortgage, or excuse me, what I meant to say was refinance, not second mortgage, so excuse me. So what you're left with is a HELOC and a refinance. Because the refinance was created after your HELOC, technically that would put it in an inferior position for payback if the house were to be foreclosed. But because a refinance is a full-on mortgage and usually worth a lot more than a HELOC, they're not going to do that. They're going to tell you that the only way we're going to refinance, the only way we're going to complete this is if the holder of your home equity line of credit agrees to this subordination clause and puts it in their agreement so that we get paid back first if the house is foreclosed. Sorry for that tangent that we went off to. Let me get back to the board, but that was a subordination clause, again, for anybody who was confused about what I was talking about, because that was not the question on the board. If a principal no longer desires the broker to act for him during the period of an exclusive right to sell listing, he may D, revoke the agency created by the listing contract, but may be liable for damages. And the reason that I wanted to throw this in here is that it confuses a lot of people as well. that, well, what confuses people is the revoking of an exclusive right to sell listing. So, technically speaking, can you guys tell me what an exclusive right to sell listing is? What kind of contract is it? What kind of contract is any listing, really? Thanks, Yash. Much appreciated. Dale, I am going to answer your question in due time. So, all listings aren't bilateral. Exclusive right to sell is. And has what I was looking for, and that is an employment contract, right? It is an employment contract, but you guys were hitting on my next question, which is that an exclusive right to sell listing is a bilateral contract. So tell me, if one party in a bilateral contract just decides they don't want to go through with it anymore, they say, nah, I'm done with this. I made a mistake. I didn't really want to sign this contract. So I'm just going to cancel this. Can they do that? Once you have a signed bilateral contract, can one party just decide, I'm good, actually, I didn't mean it, and back out? Is that doable? Dale says they can, but have to pony up for that decision. Exactly. And so that is the parallel that I wanted to draw with somebody, with a seller, quote unquote, revoking an exclusive right to sell listing before that listing period is up. It's basically just like, you deciding to buy something and then saying, oh, you know what, never mind, like after you've signed a contract, you can't do that. Like you can't just decide you're not going to honor a contract that you've signed without having to pay the penalty for that, whatever it may be. Right? So in these cases, we always say they may be liable for damages. And like Dale was asking earlier, that means that the broker could still get commission, right? Exactly. That is the penalty that the seller pays when they decide to rescind on a contract they've agreed to, not keep their word. Right. Next on the board, I am going to try and get in a few more questions. I feel like the second half of this webinar, I've gotten to do lots of concept talking. That's my favorite thing to do. So we'll see if we can get a couple more in. Tiffany asks, would there be damages in other types of contracts? Sure, Tiffany. If you agree to a 2-year renewal and you get like a greatly discounted phone with that, what happens if you cancel your phone service? That would be another type of contract in a similar type of situation. So Mr. Seller signs an open listing on his home with 5 different brokers. In this case, A, the owner must pay a full commission to all 5 brokers when it sells. B, the brokers will split the commission 5 ways regardless of who sells it. C, the owner must pay the first broker to take the listing no matter who sells it. Or D, each broker has an opportunity to earn the entire commission. The answer is D. Each broker has an opportunity to earn the entire commission. And what type of contract is it that we're talking about with an open listing? Why can anyone sell and get commission? Oops, Santana says, read that wrong. Got your answer switched. That's exactly why we always recommend reading questions completely and carefully. We do have some trick questions in here too, but I've heard that some real estate exams still use that as a standard question format. So it's important. I will say that I saw some new questions today when I was prepping this webinar, and I might have answered 1 or 2 questions wrong myself because I thought I knew what it was asking and I didn't. So even when you've been doing this for a long time and you have your head in real estate all the time, these things will still get you sometimes. It's a good reminder to just always be in the moment, be present, be zen, right? So my question before was, why is it that every broker has an opportunity to earn the commission? And it's because we're talking about a unilateral contract. Mr. Seller can consummate the contract with any broker that brings a buyer. And I had a lot of faith you guys would know that, and you followed through on that. Love it. Sorry, give me just a moment. I want to try and get a couple more good questions. Let's try this one. Oh, yeah, this one comes up too. Salesperson Beth took an offer to purchase from her buyer to broker Smith's office to present it. The offer included a $1,000 promissory note from the buyer as the earnest money deposit. Broker Smith should do which of the following upon receipt of the offer? Is it A, tell Beth the note is not good enough because it did not come with a deed? B, tell Beth she wasted her time and that he cannot accept the offer without cash or a check for the deposit? C, tell Beth that a promissory note is just as good as cash or a check for the deposit and present the offer to his seller? Or D, tell Beth she should have called him first as not to waste her time, so he could call his seller to see if they would consider an offer with a promissory note. Wow. So Dale says, if anybody's watching the chat, in Kentucky they actually use examples of farm animals and crops on the exam. For instance, cap rate is bovines divided by swines. I hope that's true, Dale, because that's hilarious and that's freaking awesome. We do have a question about a chicken coop that really threw somebody for a loop here. Like, how is that an improvement? All right. So salesperson Beth took an offer to purchase from her buyer to broker Smith's office to present it. The offer included a $1,000 promissory note from the buyer as the earnest money deposit. Broker Smith should do which of the following upon receipt of the offer? The answer is C. Tell Beth that a promissory note is just as good as cash or check for the deposit and present the offer to his seller. Nice work, everybody. I believe you guys all got that right. My personal take on this was that that broker Smith probably needs a little attitude adjustment if any of the others was correct, because he's telling Beth the note's not good enough. She wasted her time. Broker Smith probably needs a massage. All right, last question for the day, everybody. A tenant verbally agrees to lease a house for 6 months. The following month, the tenant notifies the owner that he has found a more desirable unit and will be moving out. The contract is A, invalid since it was not in writing, B, void, C, enforceable, or D, unenforceable. What does everybody think here? A little tricky action. D says that she or he has terminated because the agent wasn't performing fiduciary duty. Well, that's absolutely for cause right there, D, and the main thing you want to consider in that case is, like if you go to court, are you likely to win? You probably were right there. And Adrian says, open listings help sell the house faster by having more brokers involved. I think that makes a lot of sense too. But it's not really in your guys' best interest as agents, right? You're looking for that exclusive right to sell when you can, or at least your broker is. Cynthia says, you snooze, you lose. Absolutely. Early birds get the worm for everybody who's into eating worms. A tenant verbally agrees to a lease, or excuse me, I'm going to start over. A tenant verbally agrees to lease a house for 6 months. The following month, the tenant notifies the owner that he has found a more desirable unit and will be moving out. The contract is C, enforceable. This is similar to what we were talking about before, in that there is a contract and it's in place, right? And so you can't just unilaterally decide to exit a contract. Well, the next question would be like, but I thought statute of fraud said everything has to be in writing. Everything to do with real estate has to be in writing. One of the very few exceptions to that in regards to real property is oral leases for less than a year. They are generally valid and enforceable in a court of law. You know, again, not always, but most of the time, a lease for less than a year is still enforceable. So hopefully that makes sense to everybody. Joe likes to say, so for everybody who might still be a little bit confused, Joe likes to say that there's almost always an exception to every rule. And that's almost always true. But the exception, when there is one, is going to be little things like this. All right, makes sense to everybody? Don't see any more questions. So I think we're good. Oh, Marjorie says confused. Confused on why? RA asks, how is the math coming along? That's a great question, RA. We'll dig back into that. We were going to try and do something different with it a couple weeks ago. I'm not sure if that's still in the works. So I will look into that. You know, like we've been able to figure out a lot of the equations and what we think are going to be the explanations and such. So we will try and get that together for you guys. All right. Thank you, everybody, for showing up today, for coming and participating. We had another good crowd, lots of good participation in the chat. Even if you're not participating, it's good for you to be here and just listening or whatever it is you are doing. Always encourage you to participate in the chat, though. We've had people make lots of friends. It also helps you to learn better by thinking about this and trying to put the answers in yourself. But everybody did fantastic today. So I want to wish you guys a great rest of your Thursday. We'll be back at 9 a.m. Pacific, 12 p.m. Eastern tomorrow. And until then, have a fantastic evening. Cheers.